there was a question, am I going to get to the Secure Act? I have to get to the Secure Act because particularly for the people in this room, the Secure Act is one of the worst things that ever happened to your kids. And a lot of you don't know it. And a lot of you, even if you do know it, you don't know what to do about it. So we're going to talk about that the Secure Act that was just recently passed in, what was it, 2020, is so miserable because in the old days, if you died with an IRA or a 401k or a 403b or something like that, and you left it to a non-spousal heir, that heir was able to take distributions over their lifetime. All right, so why don't we use you as an example? Zena, all right, so let's say that Zena dies with a 403b, all right? In the old days, under the old law, and let's just say it was $1 million to pick a nice even number, and let's say that her beneficiary was 50 years old at the time. The beneficiary could then had an inherited IRA or 403b. They would be allowed to take distributions based on their life expectancy. So what does that mean? Let's just say for discussion's sake, and I don't know the exact number, but let's just say for discussion's sake that the life expectancy was 33%, all right? So they would take the factor of their life expectancy, which was somewhere around 3%, divide that into the balance, and that was the minimum required distribution of the inherited IRA. So in effect, it was 1/33 times the balance, all right? Or let's call it roughly 3%. Then the next year, it was 1/32 times the balance, all right? Now, by the way, if you're taking out 3% and the investment is earning 6%, it's actually growing even after you die. Then it was, 1/31, et cetera, et cetera. So in the early years, the inherited IRA is growing over the child's lifetime, and then when the child is older, then as the denominator went smaller and smaller, the distribution was higher and higher. Okay? And that worked out pretty well for people. And frankly, I spent many years of my career planning for the inherited retirement plan of my clients. And the younger that the beneficiary was, the greater the value of the inherited IRA. So we were planning to have, Roth IRAs going to grandchildren. So we really created tax-free empires for people. And that was a lot of fun. And then comes along the Secure Act. No. None of this stuff. We're going to make the beneficiary of the inherited IRA or the inherited Roth IRA take all that money out within 10 years after the death of the IRA owner, subject to exceptions. So this was just miserable, all right? And I'd like to show you how miserable it is. So let's say that you die with $1 million. And let's say that you died the day before this law took effect. And given certain reasonable assumptions that I won't bore you with, this is where your beneficiary would be at age 86. All right? Given those identical assumptions, except that maybe you died one day after the effective date of this law, given the same tax rates, the same interest rates, the same everything else, your beneficiary would be here. So we're looking at $2 million versus your beneficiary runs out of money. Okay, so there are some exceptions. Surviving spouse, all right? Thank goodness they're not going to accelerate the income taxes on the inherited IRA or 403B for the surviving spouse. Okay, that goes under the old rules, where the spouse can just most people call it a rollover. Technically, it's a trustee-to-trustee transfer from spouse to spouse. If you have a qualifying charitable trust, which I'm not going to cover today, but by the way, most everything I am covering is in the book. I don't think she mentioned the bonus. I think it was in the advertisement, though. But we do have, now you know the good use of this book. This book, it's only 500 pages, but it has a good table of contents. And if you're interested, we talk about charitable remainder trusts as beneficiaries of the IRA. That is another exception. If the beneficiary is less than 10 years younger than you, and that's another exception. That's typically if you're leaving money to a partner, or if you are leaving money to maybe a sibling. So that would be an example of unmarried, but within 10 years. On the other hand, even that exception isn't nearly as good as being married. Because married, by the way, the factor, it's not only the life expectancy of the beneficiary, it's the life expectancy of somebody who is the joint life expectancy of the beneficiary and somebody deemed 10 years younger. So let's say that you're leaving it to somebody that has a beneficiary, a life expectancy of, say, 17 years. Well, then it would be 1 over not 17, but 1 over 27 if you're married. Another great benefit to being married.